Okay. All right. The first obvious question, are you surprised at the verdict today?
I'm not surprised at the verdict. I think it could have gone either way.
What in your, in reading the jury's questions and following the trial, um, why did they reach this verdict? Did you believe there was beyond reasonable doubt?
So I've done enough trials to know that it doesn't really matter what any of us believe. All that matters is what those people sitting in that room believe when they start talking with each other about what they each experienced. And they have that group dynamic. That's how our jury system works. I did an interview with the Detroit News before the trial started. And I said, you know, it's interesting because I think that many of us are concerned that it, it it's it's common in northern Michigan in particular, but even in Oakland County, for parents to allow children who are teenagers to have access to firearms. And that's a normal part of American life in rural America, certainly in northern Michigan. And what was interesting about this jury is that it had a large number of gun owners and people who grew up with firearms and people who were comfortable with firearms. And so, what that says to me is that they were able to say, look, this is not putting the Second Amendment on trial, nor is it putting parenting on trial. What this case is about is there was a really exceptionally horrible thing that occurred, right? We have dead teenagers. And is this person who didn't pull the trigger at fault in some way? And there were two ways the judge instructed the jury that they could find fault. Way number one, mom could have prevented it and she didn't. Unfortunately for mom, she sent a text to her boyfriend saying exactly that. That's a really significant piece of evidence. You know, after something terrible happens, it's normal for all of us to say, oh, if only I had done that. I could have prevented that. But when people are killed and a mother says, I shouldn't have let him go to school that day, I could have prevented that. That's tough evidence for the jury to ignore in determining beyond a reasonable doubt. The second issue is this was a jury who, from their background, was sophisticated about understanding the rules of owning firearms and keeping them safely. And I think they were probably quite offended at the idea that these parents know their child is struggling with not just normal teenage anger issues. This is someone who is acting in a truly aberrant fashion, and they are completely reckless in giving this child access to the firearm. And I think that whether you're talking about driving a car or owning a gun or being a parent, there are certain ground rules that we all have to follow. And I think there was enough evidence for Prosecutor McDonald to bring the case and for a jury to find that those ground rules were not followed by this particular defendant. It was so outside the norm that a verdict of guilty for involuntary manslaughter was appropriate.
What did you think about the decision to have Jennifer Crumbley testify?
I think, first of all, her lawyer is an outstanding lawyer. And I think that Shannon had no choice. I think she had to put her on the stand. I think the jury needed to hear what was going on inside Crumbley's head. And if they didn't hear it, they would assume the worst. And that's especially true because of the text evidence and because of the affair. And so she needed to humanize her and put her up there as just I am a parent. I didn't get it right, obviously, but it's not that I'm so outrageously awful that I could have predicted this. So I think it was the right call, but the jury called it the way they saw it.
Next step.
There'll be a motion for a new trial
Okay.
by the defense. First, there'll be sentencing.
For what
And
reason?
I'm sorry?
An order for a new trial. For what reason?
Well, I don't know what the defense will come up with, but they will argue that the trial was not fair, didn't follow the rules. There were certainly pieces of evidence that were excluded that the defense wanted in. And so they will argue that they're entitled to a new trial and the verdict should be thrown out. It's in the case when a jury has already been impaneled, a motion for a new trial is really saying, it's not that we want a new trial, it's that we want the verdict thrown out and the defendant to be free. Because under the rules of double jeopardy, what would constitute a new trial in a civil case, there cannot be a new trial in a criminal case once a jury has been impaneled.
So that's a step before you would appeal it. You would just simply ask for a new trial.
Correct, in front of the circuit court judge that heard the case. Then there's a notice of appeal filed in Oakland County Circuit Court, and the file is moved to the Court of Appeals clerk's office, and a briefing schedule happens according to the court rules, where an appeal brief is filed after a transcript is made available, and the prosecutor responds, and then the defense gets to file a reply brief. And then maybe or maybe not, there is oral argument in front of a panel of 3 judges of the Michigan Court of Appeals, all of whom are elected.
So let's talk about the precedent that this sets. This is such a historic decision. Talk about that and what other states or other prosecutors might do now with this being set.
So I think that there's more talk about this than reality. And the reason is because Americans do not want a nanny state. We do not want parents routinely being charged for the failures of their children. We do not want siblings charged, spouses charged. We want individuals held account for their own bad choices and actions. That is also the norm in criminal law. There have been a few movements in the opposite direction. For instance, there were a couple of prosecutions where people encouraged people to commit suicide. They didn't actually assist them. They just said in bullying type situations or in weird supportive on websites where people are looking for the courage to kill themselves, and people will say, yes, go ahead and do it. There have been prosecutions in a few of those cases, but they're rare. We do not find routine prosecutions where people are encouraging other people to commit suicide. And why? Because it cuts against our norm that people are responsible for their own actions. I don't think we're going to get a flurry of cases where parents are charged for their children's actions. I do think that in the most extreme cases where it's way beyond normal negligence, where the horror of the crime is awful, and we also feel that really couldn't have happened but for terrible judgment and bad behavior by someone else, I think we'll see some cases. But remember, in the law, precedent is not set at the trial court level. Precedent is set at the appellate court level. So no law has been made. It's really a cultural norm. That's what we're looking at. Are we setting a new cultural norm? And I, for one, don't think Americans want a new cultural norm. I think the only new cultural norm we want is to stop mass shootings. That's a cultural norm we all want. But I don't think we want a nanny state. I don't think we want prosecutors going off the deep end and prosecuting everyone they possibly can every time someone commits a crime. I think that cuts against the grain of who we are. And since prosecutors are elected and reflect the values of the communities that elect them, I really don't expect it.
We've covered a lot. Any final thoughts?
I think that this tragedy is horrific and unspeakable. I think that the idea that you send your kid to school and you live in a town you think is safe, and you've made efforts to protect your child, and there is nothing you can do to protect your child, I think terrorizes all of us who are parents. And a truly horrible act, which damages not just the particular victims, but the very fabric of the community, cries out for justice. And I think that's what the prosecutors sought, and that's what the jury found.
David, thank you for your time today. Really appreciate it.
Thank you, Patrick.